Okay. Right. Take it Tooblack. Charging orders. Right. Okay. We might have to do this in maybe 2 sessions. I don't know. But I heard something about charging orders. So somebody is trying to charge somebody's property, and by charge, they want to introduce electricity into it. That's what a charge is. Okay. So charge and fuse. Charge and fuse. So when something has been charged, if you refuse it, that's dishonor. Okay, so you're meant to fuse it, not to refuse it. Right, so charging orders, this is something that we wrote a while back to do with an alleged debt. So these characters belong to the legal fiction world, as usual. I'll get it closer. So this was to do, solicitors wrote to someone we knew, and they said, you owe us an alleged debt, or we act on behalf of this company and you owe us an alleged debt, so please cough up, or else we're going to put a charge on your property. So this was the initial contact, I believe. Your letter dated, so obviously you put their name on it, top left. Top right you put yours. Left is creditor, right is debtor. I'm sorry, left is debtor, right is creditor. You put the reference numbers in. Dear whoever wrote to you, you write to them directly. Ideally it's suitable for you to use or to be in a direct contact with an agent or an individual man or woman who you deal with regularly in order to discharge these charges. So every time you call these organizations, you ask for a specific individual who deals with this matter specifically. So they know the status of the case, so you don't have to remind a new member of staff all the time. Right, so dear, whatever the name was, you acknowledge their correspondence. And by the way, it's black, obviously, so it's legal fiction. The language also is legalese. So we don't do this stuff anymore. We know better, but because it still exists and still legal fiction world, if they haven't repealed these acts, so if the Charging Orders Act of 1979 is not been repealed, so you can use some of this material to deal with spurious claims being put by these so-called solicitors on behalf of the bankers. You can deal with these claims properly, especially to do with charges and charging orders. Right. So in regards with the above, I have taken your advice, because in their correspondence, the cheeky sons of bitches, oh, excuse me, this these kind solicitors and lawyers, they had written to this someone we knew and told to them and said to her that, right, we're gonna try and put a charge on your property. Now the best thing for you to do is to go and seek some legal advice. So he wrote back to them and said, okay, fine, we took your advice. Okay, we went and took some legal advice, and this is what we're gonna come back with. All right. So I've taken your advice, and we also referred to the practice direction to the civil procedure rules. Remember civil procedure rules in relation to pre-action conduct. Specifically, Rule 1.1, and wish to assert my wish to settle this matter without delay and without need for court action. So their contention was that what we're going to do is this: produce some money. If you don't produce some money, we're going to take you to court to get a charging order placed on your property. So the best response always is to express your wish for settlement of the matter without delay and without need for court action. Because once it goes court, that's public. It stops being private and becomes public. And that's the switch. That's when they switch on you. And once it becomes public, they use public law to enforce it. And now you're stuck. So keep it private. Right? So you need to express your wish. If you need to assert it, you need to assert your wish to settle the matter in private and let them know you're not going to be party to any public proceedings. Explain to them you have a bag full of money. If they just come and collect it, you don't want to go to a court. All right? So, carry on. So the stuff you're going to need for numbers, because legal fiction is numbers, I also referred to the rules of the Supreme Court. Now we're talking about the Supreme Court. We're not talking about Magician's Court or the County Court. So Supreme Court being the so-called Supreme Court of the land, every other court is inferior. And because their so-called fake law is based on precedent, anything that Supreme Court says goes. All the other lower courts have to follow whatever the Supreme Court says. So Order 45 deals with enforcement generally, okay? Now, on judgment or order for payment of money. Remember that, money. Okay? Now, money doesn't exist. When you do wording like this, then you need to understand legalese. A judgment or order for enforcement of money. So when somebody wants to do this, enforce an order for payment of money, you ask him, sure, I'm not going to refuse to pay you. Just identify what kind of money you'd like me to pay you with. You see, and explain that to the court. I'm not arguing. I just need for the claimant to identify and confirm in what kind of money they'd like to receive their payment. Right? Right. So here we go. Judgment or order for payment of money other than into the court may be enforced by a writ of, I'm not going to try and pronounce this stuff, but fieri facius, FF, fieri facius, fieri facius, okay, anyway, fieri facus, third-party debt orders, charging order, or the appointment of a receiver. So those 1, 2, 3, 4, that's how they get in. So they normally use these charging orders and third-party debt orders, which are statutory. And also, if you run a corporation, they're going to appoint a receiver to take over your matters, your profits. Right, let's see. Sorry, ladies and gentlemen, there's something just going on here that he's dealing with. It won't be a minute. We'll get back to Fierafakis. Fierafakis? Is it Fierafakis? Whatever it is. Well, it stopped happening, so yeah, we're gonna go back to this. Sorry about that, ladies and gentlemen. Something was going on, and I was slightly distracted. I shouldn't be distracted, but I was. Right, we're back. Right, where are we? We're onto the charging orders. Oh, these guys are still dancing as niggas. You guys keep dancing. Oh, check this guys out. Small distraction, by the way. Now. Yeah. Oh my God. This is, as it were, apparently they called some dancing ass niggas. That's what they are. Right? You're being robbed blind and you're dancing. So you keep dancing. We're gonna be dealing with charging orders. So here we go. Right, so so in the legal fiction world, what goes on is when they need to express an interest on your property, they're going to apply for a writ of fear facies, or if it's a bailiff or one of these third party, they're going to get a third party debt order, and they have concessions for third parties, so you cannot be challenged by you like that. So they've given rights to a third party interloper, statutory rights for enforcement. So that's there. Then a charging order, which is got a process. So you're going to receive a interim charging order before they make it a charging order. So the process is, number one, they're going to do the hearing, the fake hearing in a county court, and then they're going to place the interim one. If you don't remove it, you don't challenge it properly, they're going to put a permanent one. If you don't remove that, don't challenge it properly, they're going to take a possession. And if you don't remove that or challenge it properly, they're going to do an order of sale, whereby they're going to sell your house at auction based on hypothecation, which simply means they don't have to come to your house to take possession of the property. They hypothecated, which simply means that they claim ownership without taking possession. So as long as they can prove ownership with a piece of paper wherever they are, they can sell it at auction. So that's how it's done. So be careful if you are one of these people who believes that you have a mortgage and that you have property and that you own it. You don't own it. You see, until you know who you are and how money is created and who's a true debtor and who's a true creditor, you don't own it. Okay, so enforcement of charging orders. Now the property and assets of the judgment debtor, if you allow yourself to be a debtor on which a charge may be imposed by charging order as specified by Section 2 of the Charging Orders Act. Now, proceedings for enforcement of a charging order by sale of the property charged must be begun by a Part 8 form issued out of the Chancery Division of the High Court or a Chancery District Registry, unless the High Court has no jurisdiction. All right? In which case, application should be made to the appropriate county court. Right? This is where they get ya. Everything to do with mortgage is estate law. Everything to do with mortgage is trust law. Everything to do with mortgage is Chancery Division of the High Court. Not even the Chancery Division, the Chancery of the High Court. Okay? Because the Chancery Division is not the Chancery, by the way. So you want to use the chancery of the High Court, unless the High Court has no jurisdiction. So when they take it to the county court and they sue in the county court, they're presuming that the High Court has no jurisdiction, because this is not a judicial matter, it's administrative, and that's why they do it in the county. Now the county court's limit at present is when the amount owing does not exceed £30,000. Now this was drafted, we did draft this around 2015. So in 2015, the county court's limit was 30,000. Maybe it's gone up to 50,000. Who knows? I don't know. What I'm saying to people is this: if your house is worth more than 30,000 or 50,000, the county court has no jurisdiction. How do you allow a team leader to take your property that you worked for 10 years? Are you serious? Right, I'm going to carry on. Right, charging orders. The charging orders, if you the CPR for that is Part 73. And a judgment creditor may apply for a charging order on the property or assets of the judgment debtor, which will have the effect of providing him with security over the property of the judgment debtor. So this is where the game is. You need to establish who's the judge, who's the debtor, and who's the creditor. Sorry, I'm ranting. I'm not looking at my screen. That's better. Blah, blah, blah. You see. So this is what they're doing. They're doing this. Oops, sorry. Want to go on. Go back. I'm sorry. What I mean to do is this. Right, a judgment creditor may apply for a charging order on the property or asset of the judgment debtor. Right? So whoever feels that they are a creditor and somebody owes them money, they can apply. So if you say that they owe you money, you can apply as well, as long as you identify yourself as a creditor. Alright? Now when you do that, that has the effect of giving you security over the property of the debtor. Alright? Now, for a reason that I offer a prompt remedy for all verified debts, liabilities, and encumbrances, please disclose within 14 days a verified true copy of the signed and sealed charging order issued on, this is what they wanted to enforce, a charging order issued about only 4 years ago, or 4 years after, yes, 2011, this letter was 2015. Now, the order must identify, number one, amount owed, the court where the said judgment was obtained, the magistrate, justice, or the master responsible for its issue. Okay. Now, this solicitor didn't know what to do with this one. This was a one-pager, so we didn't say fine. You want to enforce a purported charging order. Cool. Let's see it, and then we'll give you some money. So they weren't able to produce that. I think we followed it up with a second one. Yeah. So we followed up with a second one and said, I think they wrote back with some nonsense, but they didn't give us what we wanted. So the second one went out and said, we received your crap. However, there appears an error in your records that incorrectly shows that I have made no proposal for settlement of this account. I have offered settlement within the provisions of the Bill of Exchange Act and blah blah, as in accord with the relevant rulings of Lord Denning. Now, the relevance of this is that before we wrote him the first letter, this guy had given a promissory note, and they had taken it and kept it, but they still came for more. And they said that he had made no attempt to offer settlement. Right? So that's why that's there. Now, please obtain from your client, so these are solicitors acting on behalf of the bank, please obtain from the bank and forward within 7 days to us a verified copy of the agreement. Of course, we know all this stuff by now. It doesn't work. It doesn't exist. But the three things about mortgages is this. You want to see the agreement that was signed by both parties to show that the legally binding contract took place. The agreement is to contain the signatures of the agreeing parties. So, if you look at your mortgage, you're going to realize you're the only signatory. Maybe you and your wife, if you're married, or if you got your mortgage together, then the two of you are the only signatories. How does the bank have a say in your mortgage? They're not a signatory. Number two, you want a copy of a deed of assignment if they've assigned the debt. So you need to know whether or not the debt has been assigned and when it was assigned. So you want two things if it's been assigned. There's something called notice of assignment and deed of assignment. Those two things. All right. And number three, indemnity insurance on the contract, identifying and showing the sole beneficiary. I mean, you see, so those three things. Ask a solicitor to show us these things then. Three. It's not too much. Since you went to school for a long time, to the law school, and you know you've read all these books on the walls, mountains of them, surely you must be able to find the contract that you're trying to enforce. And if you sold the contract, surely you must have some piece of paperwork showing who you sold it to and when. All right? And on top of that, this contract is insured, and let's see who the beneficiary is of this agreement. It's a trust agreement. Who's the true beneficiary? Okay? I look forward to receipt of the above within the requisite time for reason to settle this matter without any further need for costly possession proceedings, man. We don't want possession proceedings. Give us the paperwork, we'll pay you, and you can F off. Right? So we don't need any costly possession proceedings. And also to fulfill, as it were, the overriding objective of the civil procedure rules in respect of pre-action disclosure. Oh boy, pre-action disclosure, my ass. A legal fiction is, this legalese world is crazy. They have all these rules that they don't follow. There's pre-action disclosure. So I'm saying to you, you want to sue me, saying you're going to take possession of my property. And I'm saying to you, please don't sue me. I'm willing to pay you. Just show me these 3 pieces of paper, then I can pay you. But you don't want that. You want to sue me still. You want to take me to court and waste my time and I have nothing to do. Come and play games in your fictitious venue. Are you stupid? Right. Whereas I do believe I am being restrained of my fundamental human rights, remember, there are no fundamental human rights. This is legal fiction, so I don't need to repeat that. It's bogus as a consequence of maladministration to pay a debt I did not owe, unless you have a case concerning the said debt. What am I talking about? Unless a prima facie, unless a prima facie case concerning the said debt can be shown. I can't stand this legalese anymore. I prefer to write in English. I hereby also reserve the right to initiate action for recovery. So this is it. So this is second letter. It's 1 page. So you give me 3 pieces of paper. If you don't, give me the 3 pieces of paper, but carry on with making your ridiculous demands. You see, you're going to restrain me of my fundamental human rights. Because you're maladministrating this account and you're trying to make me pay a debt I don't owe, and the evidence on the face of it, you cannot show any proof of any debt on the face of it. So I'm going to reserve my right to sue you for recovery of the money that I've been paying you. So this is what we talk about all the time. When they sue you for whatever amount, you don't defend the case, you make a counterclaim. That's your action. It's a counterclaim. They want 50,000, you want 100,000. Set it off. If you let them off with the 50,000, you're willing to settle for the 50,000. It's commerce. There's no flipping fundamental human rights. It's business. Who's the creditor? Who's the debtor? Who's creating this fiat currency? Is it being created by the living or the dead? The living is creating the fiat currency. So as long as the living are creating the fiat currency, the living are going to control it, and they're going to tell the dead what to do. So I don't know. This is charging orders, straightforward. So Matthew Arnold at Baldwin LLP in Watford. Ah, nice Watford. Station Road as well. Cool. Watford. I wonder if it's still good. Watford used to be okay in the old days. In the 90s. Right, so I think this is charging orders. So, yes, so this is to do with charging orders. So number one was, where is it? This one here. Yeah, yep. So if you do have a charging order, or if somebody says they have a charging order they wish to enforce, you ask to see it. So it's going to have identify the money, the amount owed, the court where the judgment was obtained, the magistrate, justice, or the master who issued it. All right. So if it doesn't have that, it's not a valid charging order. So what you do is you write to the solicitors and say, please do not try and enforce an invalid charging order, because that's against the law. And you, being a lawyer, you should know that. Get out. Sit down. Oh boy. Oh boy. Oh, and then, so if they don't respond, then you just hit them with the second one. Say, what's going on? I wrote to you, and say, okay, fine. What else? Did we have more? I mean, gosh, what else do we have here? 3. Okay. Ah, this is a sweet one. Shit. It's a good one. It's a good one. Yeah, it's a good one. Okay, here we go. So when you do your promissory notes, you see, when you do your promissory notes, if you're going to use promissory notes, you understand it's statutory. Okay? It's a statutory remedy, if you will. If you're going to use statutes, you need to stick on statutes. You cannot use statutory law in conjunction with common law in conjunction with commercial law. Those are 3 different jurisdictions. So if you're going to use statutory, you stay on statutory. If you're going to defend your claims on a statutory basis, you need to do that. However, you need to assign your documents as the authorized representative for the strawman. So every action you do is on behalf of the strawman. Right, that's another nature of my data subject notice. Right? So we do notices, we don't do request. And instructions for the personal information you hold about me to be kept up to date, accurate, and used fairly and inside the law, and only to be held and used for reasons given to the Information Commissioner, i.e., for those registered purposes, and only be disclosed to those people mentioned in the register entry. That's number 1. Number 2, please correct your records to show or reflect as accurate the information below. Now, change your computer to say this. I duly present a promissory note on the 3rd of whatever it was, directed to redeem my note on the above account, or my obligation, I should say, on the above account, obligation right here. Yeah, hang on. Do you have a key? Hang on. Yeah, I'm just making a film. Yeah, I'm just showing it off. Right, you're going to have to carry on. Got things to do. But anyway, it's there. So if you need to read the rest of it, there's only 2 lines. So it's not too difficult. Where is it? The rest is, yeah. Take this one out. And the rest is instruction. So you need to create a positive